Very good afternoon to the audience and a warm welcome to the guest of honor, Advocate Jair Rahman, who is practicing advocate at the High Court of Calcutta. So, I, Anjali Vish, on behalf of the team of Bharatiya Nyaya Shastram, warmly welcomes you and thanks you for giving us the time and empowering and enlightening the audience on the topic of importance of police investigation. Introducing Sir to the audience is an immense pleasure for me. Sir has done his schooling from St. Xavier College and has done his law degree from the University of Calcutta. Sir has entered into the legal fraternity in the year 2011 and since then serving the legal fraternity. Recently, the Sir has been designated in the post of additional public prosecutor at the district Raiganj. Sir, it is an immense pleasure to have you on this webinar. And now I would like the audience to maintain the decorum till the end of the session. All the doubts regarding the topic of the police investigation will be taken at the end of the session by me itself. Now I would like to transfer the call to Sir.
Thank you so much. I would like to thank first Bharatiya Nyaya Shastram, such a August associations, or they are doing in such a good act to bring in awareness and empowerment, enlightenment throughout the society by bringing in unanimity of all the students, all the audiences regarding legal issues, how to be dealt with, the basic rights. I'm really thankful to those persons, namely Arvind, Kapish, Anjali, of course, Anu, and Manu. Had these persons honest endeavor and their effort, the most efficacious effort had not been there, this webinar wouldn't have been possible at this time. My heartfelt reverence and venerations to all of you are there at the stage. And today I'm feeling really glad to be honored, even to be on this podium, to bring in personal awareness, share my views and experiences, what I've been dealing with since from High Court to district courts, even being in the post of additional public prosecutor at this stage. Regarding today, I would like to focus Zoom on police investigations and how the investigations is to be performed, keeping compliance with the parameters of law and the basic norms and regulations which are laid down in the provisions of CRPC. If these are to be maintained properly, then investigations will definitely bring in color, and it will be easy for the prosecutors. And if there remain good investigations, then to the prosecutors, it becomes very easy to convict the actual accused person's culprit. But if there remain latches, loopholes, and lacunas, then it really becomes very tougher for the prosecution's part to establish the case, to bring the charges at home beyond reasonable doubt. So it's very important and conspicuous that I must go on with the basic experiences what I've gained being in this sector with you guys and even the audiences who have been awaiting since long. The most important part is this: we all know, even the law students are there who must have gone through, even would be going through in future. Even you could read, if you are well conversant with the CRPC, there are so many provisions with regard to police investigations. How a police investigation is very conspicuous and crucial to maintain a criminal administration of justice, being impartial and neutral. We have to focus on this point. First and foremost, I would like to say that criminal investigation is in somewhere unequivocal obligation under international law. It's very necessary to repair our country's damaged moral authority and even to prevent similar abuses from reoccurring again. What's happening around in our society day in and day out. Purpose of every investigation is to explore in details the allegations which have been leveled against the accused person to a crystalline extent, very translucently, uh, keeping all the points very glaring and palpable. An investigation should be on, keeping a special note, proper analysis of the facts. When an investigation is on upon a complaint which has been received by any police station, their utmost duty is to gather basic information and evidences. This helps to identify the offender, somewhere the offender, and to determine whether a criminal offense has been executed or not, and helps them to decide which course of action is to be adapted for them to arrive at a just and apt conclusion by giving a disclosure of the investigation through charge sheet. So, if we explore the innocuous details of investigations, it's very important that every fact has to be analyzed in a proper way while investigating a particular case, being on the PO place of the occurrence. Proper analysis of the facts. All those facts are to be placed in a very chronological way, probable and sequential manner, so that a proper generalization in a very crystal way could be sorted out. And based on those generalizations, a proper assessment could be done. And based on those assessments, an investigating officer could discern out an apt and just conclusion regarding the factum which already have taken place. And those facts and evidences around the scenario have to be collected. And in a chain wise, all these are to be put in a very chain wise manner. There should be a co-connectivity, coherence and relevance, proper relevance. If these are not co-connected, or somewhere if coherence is missing, then the investigation would be tagged as perfunctory investigation, infructuous. This investigation won't be that colorful to help the prosecutor to bring the charges at home, to give a severe punishment to the accused persons or the culprit. First of all, to decide mens rea, culpability in mind, while carrying on the investigation, while collecting all the facts and analysis all the facts in a proper way, what an investigating officer should do to bring the case to a just and apt conclusion for the end of justice. X-ray of the anatomy of the evidences is very important. Evidences around us remains available, but there are certain procedures, and it depends. It varies from case to case, from section to section. If murder case is concerned, the investigation will be of different nature. If there is a case of kidnapping, then abduction, forceful abduction, kidnapping, and even sexual offenses, POXO matters, the investigation somewhere would twirl into a different course of action. If it's a narcotic drug psychotropic substance act, NDPS cases, the investigation is completely different, completely different. So there are some parameters which are to be maintained, right? So as to protect the case from being dissuaded, an investigating officer should be very conscious and careful with regard to minor discrepancies, with regard to embellishments and minor contradictions. Because if these things be there in the picture, it would be very tough to prove the case beyond the reasonable doubt. As if there remain any iota of doubt, then the accused definitely would get the benefit of doubt. And certainly the number of acquittals would get overnumbered than the number of convictions. So an investigating officer should be very aware of this fact. Most importantly, apart from those points, investigation includes, first of all, collection of statements under section 161. I think all of you knows this. All the students, law students, law background people are there. 161 statements is very important, collected by the police personnel. Then interrogations, interviews, recording statements, collecting evidences based on the proceeding of the issue, which is very important. It includes search and seizure. Proper seizure has to be done. At the time of seizure, in any nature of cases, whatever section may include, while search and seizure is concerned, there must be some independent witnesses to be present before that place. While seizing something, if any independent witness is missing, then that seizure would be counted as perfunctory seizure. To make the seizure effective and very, if that seizure would be instrumental to prove the case, a seizure has to be established during the period of trial. And to establish the seizure, an independent witness must be present there, whose signature has to be dragged upon the seizure list. This is very important. Then after seizure, proper leveling has to be done by the investigating officer. That those seizure articles or seizure elements, whatever I'm seizing as an investigating officer, sample, even the entire substance, even it could be drug, those should be properly leveled. If there is no leveling, then during the conducement of trial, the leveling would be very hard to be proved. That means a witness who's named in the witness column list, if he's to be summoned and somewhere he's been brought into the court for depositing his statement for his testimony, and if he's somewhere unable to identify the article seized before him, and if he says that no, there is no leveling at all, I cannot see the leveling, I cannot see the signature of the concerned authority, then that seizure cannot be proved by any extent. An accused would surely get the benefit. So this is very important, very conspicuous regarding especially NDPS cases. Apart from this, apart from this, even nowadays, modern day investigation commonly employs modern scientific methods of investigation. We all know, we are quite acquainted with the fact that forensic laboratories at their FSL nowadays, in so many cases, even in murder cases, there are some activities which are very critical to be assessed. When a murder took place, when police goes to the PO, place of the occurrence, and draw a rough sketch map during that specific time, while Caesar, some blood-stained soil, blood even used to remain in a dispersed way over the surface of so many objects. Those objects are to be collected properly, and they are to be sent to the FSL forensic laboratory for exact report that actually what it indicates. It would help to establish the case. So without forensic laboratory, without forensic expert's opinion, the case cannot be established. It's very common that police officers, while investigating a case with regard to a cognizable offense, even murder case, they're supposed to file the charge sheet within 90 days. But suppose when they're unable to file the charge sheet, unable to collect the forensic laboratory report, expert's opinion, what they are in the habit of doing, they usually give the charge sheet, and somewhere they pray at the end of the charge sheet that please let us be spared with some space, with some time, so that we can laterwards, with the gradual passage of time, we can laterwards provide the forensic expert's opinion to a supplementary charge sheet. This is very important. So without gaining FSL opinion, expert opinions report, a case cannot be concluded to a proper extent. The way it's to be concluded, it's supposed to be concluded, keeping pace with the parameters in the CRPC. Apart from this, there is some golden rule of investigation. An investigating officer, when an offense is being occurred, to determine whether offense has been committed to a proper extent, to what extent, to determine the offense, nature of the offense, any other persons or excluding the investigating officer, no any other official is permitted to touch, change, or alter anything available during the PO, place of the occurrence, until it has been identified, measured, and even properly photographed. So these are to be kept in concern. We have to keep this in mind. These are the basic procedure of investigation that a police professional should be aware of this. As soon as the police receive a call that crime committed or in progress, they send officials to the scenario to catch the criminals, even if they're to be caught red-handed. Since investigation is conducted, including pictures, measurements, forensic evidences, and other essential things which are to be complied with at the time of the investigation. If police want to search a private property during any course of investigation, if police think that a private property is to be searched, then they must first obtain a warrant or to have a probable cause that would allow search without warrant. If a police investigating or if a police officer, investigating officer IO thinks that if in a particular case which is very severe and grave, the nature of offense is very grave, then what they're supposed to do in that case to obtain the warrant is not that essential. Even authorization from the magistrate. If he feels like that I need to get into the building, I need to get into the property to search, to execute the search and seizure right now, if he has strong reason to believe or credible information which put the offense into a cognizable category, but without obtaining any kind of authorizations or any kind of warrant, by suo motu, police could get into the premises, could search out properly, could execute the search. But the reason for which he is searching without obtaining a warrant has to be reduced in writing mode. He has to reduce everything in a writing mode. But why? What's the reason? Why he is believing that this thing is about to be committed. It has to be reduced in writing. It has to be immediately sent to the superior officials for their ratifications and approval. Right. So now I would like to come straightly to the NDPS cases, narcotic drug and psychotropic substances. Nowadays, this NDPS case is standing at the very alarming stage. It's very, it's very pivotal nowadays because these cases are very tough to be established in the court to be proved beyond any reasonable doubt. Now, in NDPS cases, it had been becoming very tough for the police officials to investigate properly without keeping you know any latches to be open, any loopholes. It's very tough because any latches in an investigation with regard to NDPS cases, this follies would become very tough for the in future shortcoming future for the prosecutors to condone the latches. So an investigating officer, while investigating an NDPS case, especially, they have to keep in mind the strong parameters and norms and regulations as laid down in the provisions of CRPC and in so many rulings of the Supreme Courts or apex courts, right? So in NDPS cases, as per the data, despite seizure of 968, almost 1,000 quintals of narcotic drugs, even about 7 lakh intoxicants, in the last 5 6 years, the problem has not received due attention from the police, for the investigators, and even for the prosecutors. Due allegation of investigators and the prosecutors, as a result, the number of acquittals in such cases greatly outnumbered the convictions. For every conviction, there are about 9 acquittals. Out of 10 cases, if any one case, if conviction is being assured, then in most of the 9 cases, other 9 cases, acquittal is somewhere being affirmed. So investigating officer has to keep in mind that while investigating an NDPS cases, especially, what are the procedures they're supposed to comply with in a very sincere manner. There are a few sections 41, section 42, and even 43. All the law students who are present before in this as an audience in this webinar, they'd be shortly would become a budding advocates in the future. Some of them would practice even in the court, as an NDPS lawyer in future. If they practice in NDPS matters, especially in the court in future, it would be very helpful for them to have a prior conception with regard to the procedure of investigations. As without proper investigation, an NDPS case can never ever be given a proper direction for the ends of justice. So if you go through section 41 and 42, you must be going through all the sections, so you'll be going through in future. But let me tell you the gist and the crux of the matter. Section 41 and 42, when there is a prior information about the presence of any contraband means any drug, any substance, any article. It could be even a ganja, it could be cocaine, it could be mandrax, even it could be, codeine, fentanyl bottles, where the quantum of codeine is involved. Codeine comes under NDPS Act. So prior information about the presence of contraband article in any building, conveyance, any mode of conveyance, in any enclosed place, section 42 and 41 is applicable. So when a police officer is receiving an information, a source information from any person that an offense has already been committed, a contraband is somewhere hidden in a building, in a conveyance, or in an enclosed place in a premises. In that purpose, to go there, to conduct search, raid, sudden search, seizure, and arresting those convicts, whoever be present, whoever police personnel feels like deemed fit and proper to arrest. There comes section 41 and 42, right? But if we concern section 43, in case of section 43, uh, one has to be very conscious that when information is such, is like that, no any contraband is present in any building, conveyance, or in enclosed place. Rather, contraband is likely to be brought in by any mode of vehicle or by any mode of conveyance to a particular place that comes under the purview of section 43. So when the contraband is not being placed but is about to be brought in by a mode of conveyance, then section 43 is applicable. Based on this information, police need to start off their respective investigations, as per those provisions and parameters. which are laid down in respect of these sections. This is very important, such as Section 42 is applicable. It can only be brought into force when search, seizure, and arrest have to be effected without warrant or any kind of authorization in any building, conveyance, enclosed place which has been shot from any magistrate or gazetted officer. Under Section 41 and 42, if a police official got the information that there was some contraband hidden in a confined place in a building or conveyance, they are not supposed to bring in, they're not supposed to obtain any search warrant. They're not supposed to obtain any authorization from any magistrate or gazetted officer. If they feel like that for the sake of society, they should enter into the premises, they should simply deal with, they could they simply could break the lock, and they could enter. They could remove any obstacle to search and seize those contraband. Then they're just all they have to do, an investigating officer, they need to reduce their opinion, reduce their conception and belief in writing. Why they are doing so? uh, what sort of belief, why he's believing that there is a force in that source information, and that will be carried out for the ends of justice. There he can enter into the premises, enter into the conveyance and any enclosed place without obtaining any search warrant, obtaining any authorization from any gazetted officer or any magistrate. In case of Section 42, under subsection 1. But with regard to Section 43, if an officer got the information quite a long back that any contraband, any drug, or any substance is to be brought in to a particular place, and if he got the information long back, then as he's having ample time, adequate time, space, then at that time he's supposed to obtain a warrant, somewhere obtain authorization from the concerned authority to go to that place and to search. And before obtaining warrant, if he believes the reasons for what he needs to obtain a warrant, those reasons has to be reduced in writing. It's mandatory. And even his piece of writing is to be sent to the superior officials within 72 hours. If these are not being complied with, the investigation somewhere would be called as perfunctory investigations, infructuous. We don't carry that weight to execute the matter uh, so that the trial could be conducted in a fair manner. All right. Then, apart from this, under subsection 1 of Section 42, powers which are conferred, powers which are bestowed upon the investigating officer to enter, search, seize, and arrest without warrant is very clearly laid down in a very crystal manner. One must go through the sections to understand the weight of the procedure which our police officials should adopt at the time of investigation. And they cannot derelict, they cannot simply do away with, rather need to keep compliance with this procedure. Otherwise, the entire investigation could be vitiated, and even as an outcome, the entire trial could be vitiated. So these are the vital reasons. Also, if officer has reasons to believe that search warrant cannot be obtained without, if he feels the search warrant cannot be obtained, what's the reason that is causing him to feel like this? If search warrant cannot be obtained without affording opportunity for the concealment of evidence of facility for escape of offenders, he may enter search seize between sunset and sunrise. With regard to Section 41 and 42, the time, the time span, the stipulation period is very important. Between sunset and sunrise, the entire trial has to be conducted. If search, when the search is about to be conducted, it has to be conducted between sunset and sunrise. This is very important. Now, apart from this, where prior information related to the commission of offense, as I've told you just a moment back, Section 43 will be applicable, Chapter 4 of NDPS. There is time for obtain such warrant and authorization from the magistrate or any sort of gazetted officer. Such information recorded in writing should be recorded in writing. If the information is not recorded in writing and investigation be over in that course of manner, keeping so many latches, and if that investigation, after the completion of that investigation, while the submission of charge sheet, a presiding officer in the court, special court, NDPS judge, and even the public prosecutor, both of them have to be very aware. They have to scrutinize everything in a very proper manner going very deep into each and every bone of the investigation with due care and caution, just because of the lapses in investigations, because of minor discrepancies which somewhere remained during the course of investigation because of non-compliance of investigation as to the parameters held by the investigating officer. It's very important. Apart from this, as I've told you before, Section 41, subsection 2, and Section 42, subsection 1, and Section 50, these are to be mandatorily complied with. These will fall under the purview of mandatory provisions, and mandatory compliance somewhere has to be brought in to investigate this sort of cases. These will fall under the purview of these sections. And if this mandatory section 50, if violated, then the trial is going to be completely violated. Now, what is there in section 50 of the NDPS Act? We must know this. Because without knowing this, if a police perform an erroneous investigation, concocted investigation, and implicates someone falsely in the case, then as per the basic right, constitutional right, which is somewhere being bestowed upon the accused persons, any lawyer on behalf of the accused persons won't be in a situation to fight in the court. So one must know what are basic provisions which are laid down in Section 50 of the NDPS Act. Section 50 is saying that at the time of search and seizure, on being received with information with regard to a particular contraband, which is somewhere concealed in a building or conveyance or in an enclosed place, the moment an investigating officer with his team reaches that place, he is under obligatory performance, somewhere under strong obligation that he must, as per the parameters, as per the parameters are concerned, he must inform any magistrate of the concerned jurisdiction, any executive magistrate, of course, video could be there, and in the absence of any magistrate, any circle inspector, any gazetted officer, he must inform. And after the information, he must take down the time. He must note down the time that at what time he is informing the superior officer, he's informing the magistrate or gazetted officer for the search to be conducted. Because in the absence of this gazetted officer, one investigating officer, it could be ASI, assistant sub inspector, it could be SI, sub inspector, but not below the rank of assistant sub inspector. A search cannot be conducted. It would be barred. It would be barred for non-compliance of the basic parameters. As I've told you just a moment back, what are the basic parameters? Everything has to be reduced in writing, since from getting the information, at what time they're reaching to the place of occurrence, at what time they're entering into the premises, and before conducting the search, at what time they're giving an information to the magistrate, gazetted officer, at what time they're arriving. And the moment they arrive at the place of the occurrence, after taking their consent and taking their approval, permission, they are somewhere permitted to conduct a search. During searching any accused persons whom they feel like that he's under suspicion, he must be searched out, personal search, a search with regard to his body, or any container which is attached to his body. It could be school bag, it could be any container, any box even also. So while before searching, a permission should be obtained from the magistrate or gazetted officer. And while executing the search, an officer, investigating officer, must inform the accused person about his basic right, that he is somewhere entitled to be searched before a gazetted officer, in the presence of a gazetted officer, and even vice versa. Even an accused person is entitled to search the entire police team or a particular person who is about to execute the search. Even an accused person is permitted somewhere at liberty to search that concerned person who is about to search him, so that he might not get falsely implicated in the case. And this is somewhere permitted. So this is nicely been somewhere inserted in the basic provisions and parameters, even by the legislatures, while performing investigation regarding specific provisions regarding this sort of cases. Very neutral and impartial. This gesture has to be maintained for criminal administration of justice, for neutral criminal administration of justice, so that nobody could come up in the court and could say and could simply could hold up in the court. But the police officers, they perfunctorily performed the investigation and falsely implicated me in the case. I was not told there at that time. There was no bag attached with me. There was no any container. Even they have put the cocaine or heroin or some sample of contraband into my pockets. So these are to be maintained properly. Section 80 would speak of this all these parameters, and these are to be strictly complied with. And in case, hello, yeah, am I audible? Hello,
Yes, sir, you're audible.
right. Thank you. And with regard to the performance of this investigation, even if there is any woman and any investigating officer is about to search a woman, then there must be a lady official. As per the Supreme Court ruling, we all know all these things. And even in Section 50, it's quite clearly laid down that a lady official must search that woman with regard to keeping compliance with the strictest code of decency. Decency should not be somewhere, you know, encroached or hindered. So, investigating officer should keep this in mind throughout the time of investigation, right? Then after proper search and seizure, any contraband which is about to be seized, after seizure, all those contraband article substances, or if ganja, those are to be properly labeled with proper signature, and signature has to be engrossed, signature has to be endorsed over the level, so that it could be brought into proper identification at the time of trial, when the seizure witnesses are to be called in at the time of trial by the prosecutors, by the public prosecutor. So this is to be maintained. If there is no labeling, if there is no labeling or any endorsement of the investigating officer, then those articles won't be able to properly identify during the course of trial, and the entire trial is going to be vitiated. The entire trial will go in favor of the accused persons. But if there lie in basic or minor discrepancies, very small discrepancies or loopholes, then as in NDPS cases, all the investigations and trial, we should adopt a procedural law as Section 100 and 165 of CRPC as we follow the sections. Even these are applicable with regard to NDPS cases for minor discrepancies and for minor contradictions. Uh, Entire trial, sometimes in exceptional cases, we cannot say that entire trial is vitiated. If to an extent, a substantive material or to a relevant extent is being proved against the case, though not all the points is about to be established, then the presiding officer and the public prosecutor must keep in mind that they should adopt a proper caution and precautionary measure while conducing the trial to keep these facts remain open so that it could be proved at the end of the trial. Simply here, it cannot be said that few things are not being properly complied with. That means the whole investigation is not trustworthy, is untrustworthy, cannot be believed upon. There is no that space in during the trial of NDPS cases, especially. Right. Apart from this, there is another important point what we should follow, what investigating officers should comply with. This section 41, 42, and even 43, the section applies in case of search of person. It does not extend, as I've told you, search with regard to a personal search or a person to whom a bag or container is attached, or a person who's holding a bag or container, then this provision would be applicable with regard to that purview, with regard to that ambit. But if a person, if a vehicle is to be searched somewhere, if a vehicle is to be searched, or a enclosed place, or a building is to be searched, then a specific this provision won't be applicable. That uh, there might be a presence of a gazetted officer or a magistrate, but an accused, as in the case of while searching accused persons with regard to his body, he must be given a permission even to search in police officials, that whether police officials are holding some contraband or some sample articles, whether these articles could be put into his pocket, into the pocket of the accused persons while searching, so that in order to implicate him in any false case. This is not applicable with regard to a search of a building of any conveyance, because there a magistrate has to be present when accused persons is not at all be given a liberty to hold the opportunity that even before searching a conveyance, he is at liberty to search the police officials or the magistrate. This cannot be done. This is only with regard to a personal search, and it won't extend to the search of vehicle or any container or bag, or with regard to any building. Then, moreover, there are other some important points. Notice is very mandatory. if if with regard to a personal search, and if official got the information and any investigating officer priorly receives an information that an offense is likely to be committed with regard to a contraband, and that article is about to be brought in by vehicle in any particular place, particular more, particular juncture of any highway, then priorly an warrant or search warrant or an authorization has to be obtained from a magistrate, as I've told you before this. So before conducing that search, a notice has to be served upon. This is mandatory. Without notice, with regard to Section 43, a notice is very mandatory. If if an investigating officer is having ample time and space, then he must prepare a notice, and he must serve the notice upon the accused persons to continue with his investigation. Right?
Excuse me, sir.
Right.
Excuse me, sir. So there's a question from the audience. They actually wanted to
Right.
know about the role of police in
Mm-hmm.
NDPS case.
Mm-hmm.
How will the police
I'm
function and
telling
how
you,
will the police?
I'm coming to. Okay, okay, okay. Understood. I understood. Just a moment. I think I have given the clearance to this point. As I've told, the moment NDPS case starts with so much information, the moment a police official is receiving an information with regard to Section 41 and 42 that somewhere a contraband, that means any drug or any substance. It could be heroin, cocaine, ganja, fentanyl bottles. That some these contrabands are somewhere hidden, concealed in any building, conveyance, or in closed place. They must the investigating officer right there, then and there, must reduce the information in writing. Make a note of this. Starting away from there. They should maintain a case diary. They must reduce everything in the case diary. Make a noting of the time and what time they receive the informations, what time they're preparing their team to get started with. Then they need to go to that place. They need to send some officials, including him, the investigating officer, with the team after being ready. At what time they're
Mhm.
reaching to the place, after being arriving there. So, what would be the most
Right.
important function they should perform after being arriving there? They should, they should make some available witnesses ready after conducting a proper search and seizure. Then and there, they must inform a gazetted officer or a magistrate, executive magistrate of any nature. Even video could be done. They need to inform the BDO that we have got those information. We've come to the place of the occurrence, and we've got some information that there are some contraband articles which are hidden in that particular place. We have identified that building. We have somewhere blocked that building. Now, sir, you need to come over here. It is before your presence. We need to continue the search. Otherwise, search cannot be conducted in the absence of BDO, as I've told you before. The BDO, or in the absence of BDO, any circle inspector, CI even could be brought in that place. In presence of those officials, only search could be conducted. Only search could be conducted by the investigating officer who is charged with this matter, to investigate the matter, to proceed on. Now, while the time of investigation, after obtainment of the permission, he must give a clear cut he must give a clear cut information to the accused person that you are also at liberty to counter search even the investigating officer or other officials who are going to search you, so that you in future you might not come up in the court and say, engaging you advocate, that you were falsely implicated in this case. So this is clearly laid down in Section 50 of the NDPS Act. So this is the basic procedure, and this has to be maintained by any means under any circumstances. Without, if any officer does not maintain this, then the entire investigation will get vitiated, and for that, the entire trial would be withered. Trial cannot be conducted properly. We cannot ensure conviction in that manner. Accused will get the
Okay,
benefit of doubt. All right.
okay, okay.
Then I think
So
this point
one
is
more
clear.
yes, sir. One more question is regarding the investigation itself. So Prakash,
Okay.
a student of law, asks, how can one justify that investigation done by the IO is free and fair without any outside undue influence, that is monetary or political? And if there is any such monetary or political influence, what is the legal remedy which will be applicable?
Could you repeat the question? Your voice is breaking somewhere. Hello.
So the
Yeah.
question is, how can one justify that the
Mm-hmm.
investigation done by IO is
Mm-hmm.
free and fair without any outside undue influence, that is monetary and political? And if such monetary and political influence is in the case, then what is the legal
Right.
remedy in such a situation?
That's a very good question. And this thing only can be brought to a clarity after the completion of charge sheet. If any IO of the case, if any IO of this case perform an investigation in this erroneous manner by not keeping the fair means open, if somewhere he's somewhere induced or somewhere greased by anyone, maybe political persons or somewhere influenced, then from by perusing the charge sheet in a proper manner, any defense lawyer or especially with the public prosecutors, we simply can from the by perusing the charge sheet, it will palpably become very clear to us the charge sheet, somewhere investigation is not being done properly. Because if we go through the CD case diary, which is to be maintained properly by the investigating officer, if any case diary, what I have told before, the parameters, if any one of the parameters is not properly being maintained, suppose at the time of search, if there is no any independent witness, so there has to be a signature of independent witness while seizing an article. If those independent witness is not named properly in the charge sheet, and at the time of the trial, if those independent witnesses are somewhere summoned and called into the witness box while deposing their statement, the defense lawyer has got the opportunity to cross question him. And while cross questioning him, he'll understand that he was not at all at the time of Caesar, he was not at all present. Just police did the mere routine walk, just mere table walk, being at the police station. Because that independent witness should be aware that what are the articles which are being seized before him. If he is unable to furnish before the court uh, regarding procuring any information that I do not know exactly to what quantum, so what is the exact quantity if ganja is seized, how many packets, how many, what we call, how many container in which gajas were to be kept in, how many container were there, whether those were labeled or not labeled, whether an endorsement is there or not. If any witness is saying before the court while deposing his statement or statement that we are not aware of the fact that how many gaja, to exactly to what quantum the gaja was there, whether it's a commercial quantity or it's a small quantity or it's an immediate access, lesser quantity. If he is not being able to furnish all those informations, that means this case is somewhere concocted, got up case. That means IO simply has done the routine work being at the table. He didn't even interrogate an independent witness, just he falsely put anyone's name that he was there present and we have interrogated him. But that's a complete false interrogations. So at the time of trial, it will be very clear. But before trial, it will be very tough. It will be very tough to judge the sanguinity and authenticity of any witness, because there is a section 37, as I think you know, section 37. There is a prohibition. If any contraband article which is recovered, it comes under the purview of commercial quantity. Then under 37, section 37 of NDPS Act, bail cannot be granted under any circumstances for 180 days if it's a commercial quantity. During 180 days, the accused person need to suffer, he would suffer. But at the time of trial, well, the trial is about to be commenced, then chances are very high to get the probable remedy. But prior to that, even a judge, any NDPS judge, special judge, feels pretty shaky to consider this point and to give a chance to, enlarge the accused persons on bail. It cannot be done before the stipulation period. I hope it's clear. I think so.
Yes, sir. So there's another question posed by PhD scholar Jyoti.
Okay.
She asked if someone made a video of an offense, then how will this evidence be presented in the court? Will it be authentic on the court of law?
If someone makes a video of the offense, right?
Yes, sir. And
That's what you're
uh,
asking, right?
if someone
See,
made a video, yes, sir.
now offense with regard to NDPS case or some other case,
It's not specified basically. So maybe it is regarding other than NDPS case.
other than NDPS case. Okay. If the case is other than NDPS case, first of all, see, we know all Panchnama and we know all rough sketch map. While after being arrived at the PO place of the occurrence, investigating officer are duty bound somewhere to draw a sketch map. To draw a sketch map that around the place of occurrence, what are the connected points, connected home, what are there in the surrounding, in the vicinity, so that these questions to be put properly at the time of the trial. Even defense lawyer could take the benefit of these points. So a rough sketch map will be drawn. Photograph is allowed. Photograph is allowed with regard to availability of evidences which are somewhere being, which are somewhere available around the place of the occurrence. But at the time of investigation, while executing investigation, the process of investigation cannot be put under video. We cannot make a video recording of the process of investigation. Suppose any kidnapping is going to be the case. All an investigating officer need to do, they are allowed to take a photographs. You know, they're allowed to take a photographs. They're allowed to take some any material evidences which are available around the place of the occurrence, any weapon, blood stained soil, blood stained earth, any surface, any metallic surface where the blood is being splashed. They could take the photograph of these things, but they cannot make a videography at least. This is somewhat blurred. It cannot be done exactly, but photography is allowed. And after that, this photography, even this photography, all the things would be sent to the FSL, and one need to wait for the expert's opinion even after the filing of the charge sheet for the fair trial to be conducted. As an electronic mode of
Yes.
evidence, if an investigating officer somewhere execute a photography of the photography or video of the entire evidence, this is not allowed in that manner. With regard to rarest of the rare case, which is exceptional, highly exceptional, then only it could be done with specific permission obtained from the learned judge, presiding officer of that specific court. Before taking permission, it cannot be done. Right?
Okay, sir. So the next question is by Prakash again. If a convict is in judicial custody and police is unable to submit case diary within 90 days,
Right.
will the convict get bail automatically by default in the NDPS Act?
No, this is a very common question. Yes, uh, this is there are some basic provisions. The case which are cognizable offences and very grave in nature, offences very grave. The statutory period is 90 days. Within this 90 days, if police official fails to submit the charge sheet, then of course the accused persons would get the benefit of bail. He could be enlarged on bail by the concerned court within the concerned jurisdiction. He would be enlarged on bail. But if somewhere the police fails to submit the charge sheet, and suppose 90 days is a borderline, that's a statutory period, and just before hitting the 90 days, if on the verge of 88 days or 89 days, if investigating officer comes before the court and advises the learned court that we need some time, the investigating procedure is very complicated in this case, we're almost about to arrive at the end, and it takes a little more time. We need a little more time to arrive at the just conclusion. So I'm giving a written note that it will be spared with a little time during that case. And if there is any progress in an investigation, and up to what the investigating officer has already investigated, up to what, within that parameter, if there remains any substantive materials, any strong material against the accused person, then the bill cannot be given. The accused will not be allowed to be enlarged on bail. And if there remains no any material, no any substantive material up to that statutory period, and charge sheet has not been submitted, then the learned judge is somewhere, he is permitted, he has got ample power to enlarge the accused person's bail. Right? But to check the bail,
Okay.
an investigating officer should give a written note, should give a prayer before the learned judge. We need some time, which should be spared with some time of fortnight or another 1 week. If there is a note, then to get bail becomes very tough. I hope this question is clear.
Yes. So the next question is by Dinesh Kumar Maurya. He
Okay.
says that kindly explain how every case is decided by its police investigation.
Sorry, could you come again?
So he's asking, kindly explain how every case is decided by its police investigation. I guess he means to say that how is the police investigation the base of every case to be decided whether a person should be convicted or whether a
I think
person should
exactly.
be acquitted.
Yeah, that's a very good question, and this question has to give in a very, a very good emphasis. This is a very good question. Even we deserve the short questions that even we often and while tell the police officials. We used to train the police officials as we are empowered with the power to conduct the investigation in a proper manner, not in a perfunctory manner, so that a conviction could be ensured at the time of the trial. What happens during investigation, other than even NDPS case, or murder case, or kidnapping case, or any other cases, the team, while reaching the PO, the available witnesses, the 161, recording the statement of the 161 under section 161, whoever the witness are available at the time of the giving a visit to the PO, they must be interrogated not only they, even the amongst the team, if there are some police persons, I think at the time of seizure and even recording the statement for other purpose, even there must be a recording of the police personal statement. The more the police personal statement be recorded, any constable or ASI, whoever is assisting the team, accompanying the team, the more the police personal statements would be there in the police diary, case diary, and section 161 statements, the case would be fortified with regard to the prosecution, and the charges would be very nicely being able to brought back to the home, because the police personnel cannot vitiate, cannot sleep at the time of the trial being on the dock, because they were being accompanied by the investigating officer. If somewhere the police personnel at the time of the trial they say that we were not there, no, it's not my statement, I haven't deposed before the police personnel in this manner, then this would become untrustworthy. A learned presiding officer and even the public prosecutor won't go through the statement. So I think at the time of investigation, maximum police official statements have to be recorded with regard to investigation of any cases. And what are the points as I've laid down before regarding NDPS or any other matters? Suppose in the matter of kidnapping case, forceful abduction and then concealment. If the girl is recovered, and during the process of recovery, there must be a police team. So I think each and every member who are assisting the investigating officer, their statement must have to be recorded. They would fortify the case. But without recording the statement of the police personnel, if I simply record any passersby, any other independent witness, the case won't be under that fortification. This has to be kept in mind. And any person who is helping the police personnel, and who is even helping the police personnel to recovery of any weapon, any article, any sort of weapon, means any sort of weapon or anything which is used at the time of commission of the offense, but those are being concealed somewhere. If anyone is leading to the recovery of those articles, their statement has also to be recorded. Even who are lying in connivance, even their statement has also to be recorded properly to fortify the case. But most of the cases, what police officials, investigating officers used to do, they're in a habit of doing this. They never record the statements of those assisting police officials, even those persons who are lying in connivance of those persons. The offense, if it's accomplished, then their statement has to be recorded. But in most of the cases, these latches remain open. They never take the statements of those persons, and because of this reason, the base becomes very weak. This is to be kept in mind, right? Hello.
Hello. So due
Yeah,
to
yeah,
the short
yeah, I
of
can
time,
hear you.
due to the short of time, we won't be able to answer the questions, other questions posed by the students, because I guess the meeting itself will end by 6 o'clock. So it is.
Yeah, yeah. Still, you
Uh,
having a 5 minutes, I think so.
so
Still, it's 5:55. If any vital question is there, which is to be answered, then I'm there.
Yes, sir. So basically, I feel that the students found this a very interactive session, and many concepts about the criminal justice system have been cleared. Even the investigation by the police officers have been clear to the audience. And
Exactly.
I would like to thank the audience as well to be very patient with us, and sir, a very warm thank you for enlightening the students about the importance of police procedure investigation, because this investigation is a very important process in the criminal trial system in India.
Exactly. I'm very glad, and even I would like to say that regarding criminal investigation and criminal process of investigation to be conducted in a very fair manner, its jurisdiction is so vast, just like a vast abyss of ocean. It cannot be concluded within such a short span of time. We are really time bound. If time had there be a little more time, I would be in a situation to explore more details regarding investigations against the allegations being leveled, how to be investigated. More things are there. Might be some other day. Anyway,
So maybe we can discuss this in another session, because I think
of
the
course, of
students have
course.
found this session very interesting.
Of course, I'm always
Okay.
there, because this sort of process and this sort of topic, the topic which I have chosen also, this topic is very fast. During the lockdown days, we are not being that busy. We are not being conducting the cases in such a manner way it used to be done during the course of normalcy, normal days. So I'll be available in even in next week also in the next session, no problem. I'd like to give my time to you guys for bringing proper enlightenment and empowerment among the students.
Thank you, sir. Even Bharatiya Nyaya Shastram would like to thank you for your precious time and knowing the practicality of the police investigation procedure. So we would like to thank you.
Even I'm feeling heartfelt reverence and veneration from your past for somewhere bringing me here to give an opportunity. I'm really thankful to you guys. Keep on doing these sessions as this will bring really an awareness among the students. And in future, there have been situations to really be a good lawyer or even to point out any investigation which comes to the purview of concoction and folliable investigations. One must know the law of the land. And it will become easy for the persons to know their right, know their awareness. Thank you.
Yes, sir. Sure, sir. Thank you, sir. Thank you so
And
much.
thank you every team member who are responsible for bringing me here. I'm really thankful to them.
Thank you, sir.